Right to effective communication in domestic violence cases. This is part of an informational video series. This informational video is created and produced by CHS Training and Education Program. This video is intended for informational and learning purposes only and shall not be construed as legal advice. CHS is not liable for any misuse of information contained herein. The Americans with Disabilities Act, ADA, is a federal civil rights law that prohibits discrimination against people with disabilities in everyday activities. The ADA prohibits discrimination on the basis of disability. The ADA guarantees that people with disability have the same opportunities as everyone else to enjoy employment opportunities, purchase goods and services, and participate in state and local government programs. The ADA has 4 main sections or titles. If you are interacting with police and courts because of a domestic violence case, you have the right to effective communication under Title II of the ADA. Title II requires state and local governments to provide people with disabilities an equal opportunity to benefit from all of their programs, services, and activities. This includes courts and police. They may not discriminate against you because you are deaf, deafblind, or hard of hearing. If you are experiencing domestic violence, know that you deserve better and that this is not your fault. If you are in an emergency, call 911. There is help. CHS can work with you to create a safety plan and escape. You can also call the National Domestic Violence Hotline at the number on the screen. If the police are involved, know that you have the right to a sign language interpreter. If you call 911, be sure to tell the dispatcher that you need a sign language interpreter. When the police and emergency personnel arrive, again, tell them that you need an interpreter for effective communication. CHS has pocket cards you can use to explain this. If your abuser is also deaf, they should request their own second interpreter. If you choose to get an order of protection or any other legal support from the courts, you have the right to a sign language interpreter for effective communication. Your courthouse may have an office of interpreter services, or you can tell the circuit clerk, judge, or other court staff that you need an interpreter. Interpreters must have a specialty license to interpret in court. As you can see in the picture, there may be multiple sign language interpreters with different roles. There may be an interpreter for one party, both parties, or one court interpreter. This will depend on your case. A proceedings interpreter, PI, works for the court and interprets everything spoken by any party that is recorded. The PI usually stands in front of the courtroom near the judge. Often, PIs work in teams of 2 and are sworn in by the judge. PIs cannot interpret between a lawyer and a client. The table interpreter, TI, interprets attorney-client privileged communications. This is private and not recorded by the court. The TIs are not sworn in by the judge. The TI has 3 main roles: interpret communication between attorney and client, act as an expert in interpreting and deafness, and monitor the proceedings interpreter if the TI table interpreter notices an error by the proceedings interpreter. They will tell the attorney so the attorney can object if they choose. Because the TIs sit with the client and interprets between the attorney and a client, they cannot become a proceedings interpreter for the case. If your abuser is also deaf, they have a right to their own table interpreter. For criminal cases, interpreters who work for the prosecution in the investigatory stage, whether they worked for the police, the prosecutor, investigators, including applications for protective orders, CPS or APS investigations, or grand jury, cannot become proceedings interpreters. Interpreting for both the investigation process and the court hearing is a conflict of interest and not allowed. Domestic violence situations are scary. CHS has advocates who can work with you to advocate for your rights to effective communication and provide support through the court process. Contact us at any time. Our information is on the screen.